So my name's Amanda Piper. I'm a legal executive in the private client team at SME Solicitors. If somebody gets to the stage where they need to move into a care home, there's always a question of how are they going to pay for their care fees. People may come along and say, well, I've got a house, I've got savings. Is it all going to get eaten up in care fees? We're there to guide them, explain how the processes are, what is available to them. If they have to self-fund their care, there are thresholds that they get through. If somebody has assets over £23,250, they have to pay for their care. If you've got a husband and wife and one of them goes into a care home, then you would want the local authority to be able to disregard the value of the property because you've still got somebody living in it. But obviously if you've only got one person living there, so if somebody's passed away and the wife is left and she has to go into a care home, then she will then be required to pay for her care and she may have to sell the property in the future. So it may be that they can enter into what's known as a deferred payment arrangement. That is where the local authority will say, we will pay for your care, and if the property is sold in the future, then you pay it back. Or it might be that the property may be held in a trust and they no longer own the property. The trust owns the property and they're allowed to live in the house for their lifetime. If that's the case, then it might be that you have to get into discussions with the local authority as to actually who owns the property. The local authority might challenge it on the basis that they've done it to deprive themselves of the asset, or it might be that it's been there a long time and then again they have to disregard it. If someone has to go into care and they do a financial assessment, it's a good idea to have all the information available at that time, because if there's, for instance, a trust, then you can provide them with a copy of the trust document and you can start speaking to them then. What you don't want is for it to go on months and months. You're still having to pay for your care during that time, and then there's issues further along the line. So if the local authority don't accept the trust, then it could be a case of, having to get into lengthy discussions with them as to the reasons why the trust was created. If somebody's created a trust and then 2 months later they go into a care home, then you're highly likely to have them actually challenge it and say you did it because you knew that you might need care in the future. If, however, say you did it 20 years ago and you were fit and well at the time, there were no concerns, you weren't visiting the doctor regularly, and you wanted to basically make sure that the children were looked after, then it's harder for the local authority to say you've done it because you knew in 20 years' time you'd have to pay for your care. We never know what's around the corner, and if you can get all your affairs in order at an early stage, it just makes things easier if something does happen. So the Court of Protection is where you have to go to if somebody doesn't have any power of attorney in place and they've lacked the capacity to be able to give instructions. So it may be the case that they might have had a stroke, that they might have some form of illness that has come on quite suddenly. The social workers, doctors are saying they're not going to be able to return home. Somebody needs to be able to manage their affairs. Now, if they've put their affairs in order and they've got lasting powers of attorney in place, that's okay. But if they haven't got anything like that, then you have to go to the Court of Protection and you have to make an application to the court for someone to be appointed as a deputy. Now, it can be very time-consuming, it's expensive, it's really the last resort. If you can get the power of attorney, get it done whilst they can give instructions. The Court of Protection will also be able to make decisions with regard to health decisions. So if somebody has lost the capacity, you might have someone who can manage somebody's finances, but not necessarily a decision with regard to their health. There could be issues in that they're at risk at home and they need to move to a care home, but the person involved won't agree to it. You can't necessarily force someone out. It can be quite difficult. So you can go to the Court of Protection and ask the court to actually make what's known as a best interest decision, whereby the judge will consider what it is, what the risks are involved, and actually whether it's better for that person to be moved to a care home. It could be against their free will, but it is there for families to go to if they are very concerned about family members. So if somebody is worried about a family member, so if they think that they're struggling to manage, then we always say come along and have a chat with us. We can then If possible, speak with a family member. See if we can get powers of attorney for them. If we think actually probably no, then we can guide them through it, and then we can obviously arrange for the applications to be put before the court. So the earlier you do it, I wouldn't necessarily, it's easier, but it takes off some of the stress. It's hard enough having to make the decision. When you've made the decision, you then don't want to have to spend 6 to 8 months arguing over trivial matters that are actually vitally important in being able to get the person effectively somewhere safe. Sometimes you can see what a family are going through, and you kind of have to step back and say, we can take this pressure off your shoulders. You've got enough going on looking after the family member. Let us deal with the other side, and we can look after you.